A CVL is also known as a Creditors Voluntary Liquidation. In its simplest form, it's a formal winding up process for a company that is suffering financial distress. When it becomes necessary is when a company reaches a point where it's struggling to meet payment of its creditors, it's receiving threats of winding up petitions or legal action from its creditors, it's no longer able to manage its ongoing daily obligations in terms of payment of wages, overheads, and the director needs to make a decision to proactively deal with that outstanding situation. If the business is no longer viable, then that is a case of looking at the liquidation process as that formal winding up to close the doors on the business. A CVL becomes the best option for a business facing financial difficulties when there's certain pressure points there for the business. Those pressure points ordinarily will be threat of legal action from creditors, cash flow issues, whether that's meeting payment of ongoing liabilities, meeting payments of staff, and generally being unable to keep up with the day-to-day operations of the company. The benefits there for the business in seeking to go down the CVL route is it draws a final line in the sand for the business's operations, but also in respect of the debts that it is incurring. What that does is it protects the interests of the creditors, which is of course the duty of a director to do so wherever possible. When considering if the business is looking at facing a liquidation process or any type of insolvency, you need to be keeping an eye out for some key triggers there. They could in the simplest form be that you are falling behind with HMRC payments, right through to more severe implications of threat of winding up proceedings against a company. We've got a lot of businesses that will suffer general cash flow issues, whether that's they've missed one payment with a supplier, they're unable to meet the wages of their employees at the end of the month, they're getting chased from creditors more often than they previously have done. And these are all key things to be looking out for. The key thing for a director's perspective is to seek help as soon as possible. Don't wait for those final pressure points on the business before seeking that professional advice. The sooner that a director approaches an insolvency professional, the more likelihood that there could be some form of rescue of the business in some form. That may not be that the current business and current limited entity moves forward, but if there is a way of preserving an element of the business and also the employment of those that work for the business, then that's the best outcome for everyone. The initial steps of the CVL process are making sure that the CVL process is actually the right thing to be doing for the company. And what that involves is an initial information gathering exercise with the director and its financial advisors. And that's to make sure that there's nothing else that can be done for the business as a first step. Where it's concluded that liquidation is the right step to take, it's then further information gathering to prepare for starting that process. The process itself is started with an initial meeting of the board of directors. What that does is that then convenes a shareholders meeting and what's known as a decision of creditors. That shareholders meeting, which takes place usually at least 10 days after the board of directors meeting, resolves to wind the company up at shareholder level. At that point, the company itself appoints a liquidator. It's then for the creditors of the company to formally appoint a liquidator themselves as well. Once that creditor's decision has happened, the company is formally in liquidation process at that stage and then moves forward into the formalities that the liquidator has to deal with statutory obligations to notify relevant parties like Companies House, advertisements in the London Gazette, and most importantly for a liquidator to take their duties forward to realise the assets of the company, and they do have formal duties to investigate the conduct of directors as well. I think one of the biggest misconceptions with a CVL is that there is an automatic ban on directors from being a director moving forward. There's a concern that having one company go through liquidation may affect other directorships that a director already has. There's no immediate impact on you being a director moving forward. or in respect of other companies that you have, and that is very clear. That would only come into play if you were disqualified to act as a director for a period of time as a result of any misconduct from operating the company that has entered liquidation. A liquidator does have a duty to report to the insolvency service in respect of misconduct, and it is for them to make a decision whether disqualifications are relevant, but it's not automatic. Another misconception is that a director will become personally liable for the company's debts. Where you're dealing with a limited company, there is no automatic personal liability on directors for a company's debts. That would ordinarily only ever come into play if a director had provided a personal guarantee for one of the company's debts. Likewise, where a company has a director has other companies, directors are concerned about those debts being passed on to the other companies. Again, as long as those other companies haven't provided what's known as a cross guarantee, it's very difficult for any liability to be passed on to those other entities on the basis that they are separate legal entities themselves. There's also concern that a director may not be able to start any new companies in the future at all. The main thing for them to be concerned about with new companies is the reuse of a company name. Where a company goes into liquidation, that director is prohibited for a period of 5 years of setting up a new company with a name that is the same or similar enough to suggest association. It also applies to any existing companies that they have that have a period of less than 12 months trade with them. So the main impact that a CVL could have on directors is in respect of potential disqualification if there has been any form of misconduct there. That would only come about as a result of the investigations into the conduct of the company, its directors and the directors within the last 3 years. As part of that process, there's a report that goes to the insolvency service, and it's for them to make a judgment as to whether there is any proceedings to be brought against that director for a disqualification order for between 1 to 15 years. Other potential implications on a director are where there are personal guarantees provided in respect of debts. If a debt has been personally guaranteed, the liquidation process will trigger that personal guarantee to be called upon by the creditor. If there is no agreement with that creditor personally to reach settlement of that debt, then there could be implications on the director's personal credit rating, but that is never automatic. It's usually if there is some form of default on that personal guarantee. The main responsibilities of a director in liquidation process is that they need to make sure that they're cooperative with the appointed liquidator, office holder, insolvency practitioner. As long as they are cooperating and providing the information that's required, delivering up assets, protecting assets and protecting the interest of creditors, then they're doing everything that they should be doing in terms of their fiduciary duty, which is the duties that a director has anyway through the Companies Act whilst they're operating that company. The key thing for directors when they're reviewing the financial position of the company is to make sure they're acting in the best interest of all stakeholders, which includes creditors and shareholders. It's a self-review really as to whether the steps they're taking are in the best interest of everybody as a whole. Are they taking steps to deal with an outstanding position, or are they blindly continuing to trade whilst knowingly insolvent? Are they incurring further debt whilst knowing that the company is not going to be in a position to repay that debt? The risk of taking such actions are that they could be accused of wrongful trading. Wrongful trading could be quite serious for a director. It can lead to personal liability in respect of the company's actual debts, and it can also lead on to disqualification to act as a director in the future, from anything from 1 year to 15 years. So it's a really key thing to keep an eye on how a company is operating financially, and even when there's the slightest pinch point with a company from a financial perspective, seeking financial advice at that time so that you're not falling foul of potentially wrongful trading accusations. The biggest impact on creditors as part of any liquidation process is that they're not getting their debt repaid immediately. They've got to wait a period of time before they receive any indication as to what amount will be repaid, and then they've got to wait for the liquidation process to actually play out before they receive any return. There are instances where creditors won't receive a return in respect of a liquidation, and at the end of that process, those debts are ultimately written off, and the creditor has to suffer the loss from the liquidation process itself. A creditor's rights during that liquidation process are significant. There's a standard rank of priority in terms of who gets paid first in a liquidation scenario. So that's the first right of a creditor, dependent upon where they sit in that ranking. You have banks with fixed charge security sitting at the top, all the way down to standard creditors, which will be classed as unsecured non-preferential creditors, who are normally your standard trade suppliers, banks that don't hold security, landlords, utilities, etc. But the rights of those creditors are to have a say in the proceedings. When a liquidation process is commenced by a director, creditors are invited to vote in respect of who the liquidator should be. They've got a right to nominate another liquidator to that the director is suggesting, if for whatever reason they wish to do so. And they also have the rights to nominate themselves what's known as a liquidation committee. A liquidation committee can be a party of between 3 and 5 creditors who get to have a general overarching view of the liquidation process itself and a say in some of the decision making, including what a liquidator is paid. They generally get some more regular updates than the standard body of creditors as well. Once the liquidation process is complete, the liquidator will file a final report at Companies House. This will also get circulated to the creditors and the shareholders of the company. This report provides everybody that's concerned with the process a final snapshot of what's happened, what the return to creditors has been, and how the assets have been realised and those funds used during the process. Shortly following that report being filed with Companies House, usually between 2 to 3 months after, the company is then dissolved. Any outstanding debts at that point that have been unpaid as part of the liquidation process are written off. A director can start a new business following a CVL process. They do need to be careful when doing so to make sure that they're not falling foul of certain parts of insolvency legislation when doing that. The key thing is the reuse of a company name. When a company goes into a liquidation process, that company name and its trading style, they become prohibited for that director to use for a period of 5 years. The rules around it are dictated predominantly by the Insolvency Service, who make a judgment as to whether a director is acting in a position of management or as a director of a company that carries a name that is the same or significantly similar to the company name that is in liquidation. When a company director is considering trading a new business that has a name that could be similar, it's very much recommended that you seek independent legal advice at that stage. If a business, a new business is set up by a director with the intention of having a name that is the same or similar, then in order to do so, they would need to seek either permission from court to utilise that similar name, or they need to have purchased the business assets of the company out of liquidation and then followed some significant legal steps thereafter to make sure that creditors are aware that the director is trading that similar company name under a new entity. Additionally, directors need to be aware of any existing businesses that they have that carry that similar name or same company name to a degree. This is where a business has been trading with that similar name for a period of less than 12 months. If there's a period of less than 12 months trade with that business that's got a similar or same company name, you again need to be seeking legal advice as to the steps to take to move that business forward. That being said, that's the main stumbling block in new businesses for a director. The general rules regarding the Companies Act then follow regarding a director's fiduciary duty and making sure that steps being taken with the new business are in the best interests of creditors. You can also find that a new business may suffer from creditors having reduced credit terms with that company. They may seek that invoices are paid on pro forma initially, just while that initial trust is built up with the new business and trading forward. But that's the same with any new business in that regard.